admit his primary presentation, so if need be, the court will also extend additional time to you.
Thank you,
May
Your
it
Honor.
please the court?
Good morning. My name is Allison Hartman.
Good morning.
I
My name is
represent the state of
Allison Hartman.
Mississippi.
I
On
represent
behalf of
the state of
Attorney General
Mississippi.
Lynn On behalf of Attorney
This
General
court should
Lynn
affirm
Fitch.
Carly Gregg's
This court should affirm Carly Gregg's
first-degree murder
conviction,
an attempted first-degree
and her
murder
life imprisonment
convictions,
sentences,
and her life
because every
imprisonment
aspect of her
sentences,
trial was
because
fair,
every aspect of
and no
her trial
errors
was
were committed
fair,
in the trial court.
and no errors were committed
Greg
in the trial
raised several
court.
issues related
Greg
to both
raised
the
several
guilt
issues
and
related to
penalty
both the
phases
guilt
of her trial
and penalty
Most of
phases
those
of her
claims are
trial.
waived because
Most
she
of those
failed
claims
to
are waived
contemporaneously
because she
object
failed to
or otherwise
contemporaneously
raise those
object
issues in the trial
or
court.
otherwise raise those
But even
issues
if
in the trial
we
court.
set the waiver,
But even if
bar
we
aside,
set the waiver,
all of her
bar
claims lack
aside,
merit and should
all
be
of her
denied.
claims lack merit and should
I'd
be
like
denied.
to start with the
I'd like to
penalty
start
phase
with
issues
the
because it
penalty
seemed like
phase
that was
issues
what
because
majority
it
of
seemed like that
opposing
was
counsel's
what
argument
majority of
focused
opposing
on,
counsel's
and then circle
argument
back to
focused on,
the guilt
and then
phase
circle back
issues
to
as
the
time
guilt
and
phase
interest
issues
allow.
as time and interest allow.
It's critical to establish at the outset.
It's critical to establish at the outset
Greg's sentence for
that
first-degree murder.
Greg's sentence
is life
for first-degree
without the
murder
possibility of
is
parole.
life without the
And
possibility
her
of
life
parole.
imprisonment sentence
And
for
her life
attempted
imprisonment
first-degree murder.
sentence for
Where do you see in the
attempted
record
first-degree
that that's her
murder.
sentence? Where do you see in the record
Your Honor,
that
we have
that's
to
her
look to the
sentence?
parole statute.
Your Honor, we
and
have to
the
look to the
sentencing
I
parole
understand that
statute
the parole
and the sentencing
statute, I understand that
parole
the
for
parole
somebody who's
statute
been sentenced to
prohibits
life.
parole for somebody who's
And I
been
understand we
sentenced to
have
life.
cases that
And I understand
say
we have
essentially
cases
that means every sentence is life without the
essentially that
possibility
means
of
every
parole in
sentence is
effect.
life without the possibility.
But there's
of
an
parole
issue in
in
this
effect.
case regarding a
But there's
jury
an issue in this
instruction,
case regarding a jury instruction
and regarding an illegal sentence.
and regarding an illegal
And-
sentence. And because of that, I think it's important to
Because of that,
to
I think it's
see,
important
to
separate
see
from the application of the parole statute.
separate
for a
from the
minute, what she
application
was
of the
actually
parole
sentenced
statute
to.
for a minute.
So
What,
she
and the
was
sentencing
sentenced to.
statute in this case,
So
and the
she
sentencing
allows
statute in this case
for two sentences.
allows life for two sentences, life in prison, if
Life
that's set by the jury, life in
prison if
and
that's
a
set
term
by
of
the
years,
jury,
and
All
a term of
right, so-
years. All right,
So-
the sentencing statute, I mean, sorry, the sentencing order in this case, the sentencing order in this case, so absent the application of a parole statute, which itself could be amended by the legislature, which itself could be amended by the legislature. I don't understand, I mean, I get why you say the effect of her sentence. I get why you say the effect of her sentence. And I think that's relevant to Miller, and I think that's relevant to the Miller. But to the illegal sentence in the jury instruction, to the illegal sentence in the jury instruction, I think it's relevant. So what the sentence, you will agree with me. So what the sentence, you will agree with me. The sentencing order
Yes, Your Honor,
says,
it
you will
does.
agree with me that that is one
Yes,
of
Your
the
Honor, it
legal. You will
does.
agree with me that that is one of the legal
Yes,
sentences
Your Honor.
under the sentencing
So
statute.
the legal
Yes, Your
sentence
Honor.
under the statute,
So the
the
legal
amended
sentence
statute,
under the statute,
like
the
you
amended
mentioned,
statute,
is life
like you
imprisonment.
mentioned,
If the
is life
legislature were to
imprisonment.
amend the
If the
parole
legislature
statute
were to amend
in
the
this
parole
next
statute,
session,
I don't know any
in
reason
this
they
next
would, but if they
session,
did,
and they were to
any reason
remove the
they would, but
language
if
that
they
says
did,
you're
and
no
they would
longer
remove the
eligible
language
for-
that says you're no longer
the language that
eligible
says you're not eligible for parole.
The language that
if
says
you're
you're not
convicted
eligible
of
for
first-degree
parole
murder.
if you're
That's
convicted
what
of first-degree murder.
Relegates this effectively to a life
relegates
sentence.
this we've held.
Effectively to a life
Uh,
sentence we've held.
then all of a sudden she's no longer
sentenced to life.
Then all of a sudden she's
Without
no longer
possibility
sentenced
of
to
parole.
life.
Is that correct? Without
I
possibility of
think,
parole. Is that correct?
yes, Your Honor.
I think
because that's
yes,
what the
Your
court
Honor,
did.
because that's
versus
what the
State.
court
That was
did
this
in
court.
Johnson versus State. That was
Johnson
this
was
court.
originally convicted
Johnson
in
was
2000,
originally
which was
convicted in
pre-Miller,
2000,
and he
which
was
was
sentenced to
pre-Miller,
life without the
and he
possibility
was
of
sentenced
parole,
to life
which
without
was
the
under
possibility
the
of parole,
essentially
which was under
mandatory
the
life
essentially
imprisonment
mandatory
without parole
life
sentence,
imprisonment
pre-Miller.
without parole sentence,
And he was
pre-Miller.
He filed successfully
he was-
filed for
he filed
PCR,
successfully filed
and he
for
received a
PCR,
resentencing hearing,
and he received
in the
a
trial
resentencing
court,
hearing,
and the trial
in the
court
trial
conducted
court,
the Miller
and the
hearing,
trial court
considered
conducted
the Miller
factors, and
considered
again
the Miller
sentenced him
factors,
to life
and again
without the
sentenced
possi-
him
or life
to
imprisonment
life
without the
And then
or
this
life
court
imprisonment
interpreted
and then this
that life
court
imprisonment
interpreted
language, that
which
life
is
imprisonment
identical to
language,
what we have
which
here,
is identical
and
to
it
what we
considered
have
the
here,
parole statute,
and it
and
considered
said
the
that
parole
you have to
statute,
read the
and
sentencing
said that you
statute
have
and
to
the
read
parole
the
statute
sentencing statute
to
and
understand
what
the
to
life
understand what
actually
the life
what the life
imprisonment
imprisonment
statute
actually
what the life
is.
imprisonment
And
sentence
that when you
actually
consider those
is.
two statutes
And that
in
when you
tandem,
consider those two
essentially
statutes in tandem
under the amended
essentially
sentencing statute,
under the
life
amended
imprisonment
sentencing
is
statute,
life without the
imprisonment
possibility
is
of
life
parole.
without the possibility
And
of
I
parole.
think that the court can just
And
look to
I think
its
that the
own
court can
decision
just
in
look
Johnson
to
versus
its own
State,
decision
which is really
in Johnson
instructive
versus State
on
which
this
is
issue
really instructive
because it's one of the
on this
only
issue
cases that
because
actually
it's one of the only cases
interpret
that
the
actually
amended
interpret
statute
the amended
that went into
sentencing
effect in
statute
July of 2024.
that went into effect in July of
And
2024.
this court recognized there that you
And
have to
this
read
court
the
recognized
sentencing
there that you
statute
have
and
to
the parole
read the
statute
sentencing
in
statute
tandem
and the parole
to give
statute
effect
in
to
tandem
what life
to give effect
imprisonment
to what
actually
life
means.
imprisonment actually means.
Because as Your Honor mentioned,
because
life
as Your Honor
imprisonment is the
mentioned,
maximum.
life imprisonment is the
penalty under
maximum, the sentencing
penalty
statute.
under the
And you have to
sentencing
look to
statute.
parole
And you
eligibility
have to look
statute
to
to
parole
determine
eligibility
what
statute
life
to
imprisonment
determine
actually means.
what life
Parker v.
imprisonment
State,
actually
we
means.
held that.
Parker v. State,
There should
we
be a
held that
determination when that
there
parole
should be a
statute is in
determination
play.
when that parole statute is in play.
It's awkwardly worded, I think, but we
It's
said.
awkwardly worded, I think, but we said.
Whether or not the defendant should be sentenced to a
Whether or
term
not
of
the
life
defendant should be
imprisonment
sentenced to a
with
term of life
eligibility
imprisonment,
for parole,
with
notwithstanding the
eligibility
parole
for
statute.
parole, notwithstanding the parole.
Was there any attempt
to
was
instruct
there
the
any
jury on
attempt
that,
or
to
to
instruct
to
the
raise
jury on
Parker,
that,
or
or
to
to
raise
raise
Parker,
to
to
try to get a
trial court,
determination that the life
to try to get a
sentence should be,
determination that the life sentence, notwithstanding the parole statute, notwithstanding the parole statute?
I'm sorry, are you asking whether,
I'm sorry,
the
are
trial
you
court
asking
should've-
whether,
the
I'm
trial
asking
court
whether or
should've-
not there was.
in-
I'm
attempt
asking
made
whether or
to
not
follow
there was an
Parker's
attempt
mistake
made to
in the
follow
trial
Parker
court
v.
if
State.
you're gonna
In
sentence
the trial court.
Ms. Gregg
If
to
you're gonna
life without the
sentence
possibility of
Ms.
parole
Gregg
and
life
claim
without
that
the
it's because
possibility
the
of
parole
parole
and
statute,
claim that it's because the parole
forbids
statute,
parole. And Parker,
you know,
we said
forbids
there needs to be a
parole.
determination
And Parker, we
whether
said
or
there
not
needs to be a
determination
with the
whether or not that
possibility of
sentence
parole,
should be
notwithstanding
life with the
the parole
possibility of
statute.
parole,
I'm
notwithstanding
asking
the
you if
parole
that
statute.
procedure that was laid out.
I'm
in
asking
Parker
you
was
if that
followed.
procedure that was laid out.
It
in
was,
Parker
Your Honor,
followed.
at the
It was, Your
sentencing-
Honor,
at the
jury
sentencing-
instructions conference,
jury
instructions
the
conference,
court and the parties were
the
discussing.
court and the
the
parties
sentencing
were
instructions,
discussing
and
the sentencing
there the court
instructions,
was looking
and
at the state's
there the
proposed
court was
instructions-
looking at the state's
and the
proposed
defense-
instructions
proposed
and the
defense,
defense's
and
proposed
the court and the
instructions.
parties
And
both
the court and the
acknowledged
parties
that under
both
Miller,
acknowledged that,
excuse me,
under
under
Miller-
yes, under Miller there
excuse
had to
me,
be
under
Miller
complaint
there had to
hearing,
be
but also
Miller complaint hearing
that
but
under Mississippi
also
sentencing
that
statute
under
as
Mississippi
amended,
sentencing statute
life
as amended
imprisonment meant
life
without the
imprisonment
possibility
meant
of
life
parole.
without the
So
possibility
all the parties
of parole.
recognize that under
So
that
all the
first
parties
sentencing
recognize that
option
under
in
that
the
first
instruction,
sentencing
life
option
imprisonment
in the
was
instruction,
effectively a
life
life without
imprisonment
parole
was
sentence.
effectively a
That's
life without
effectively
parole
true,
sentence.
but we, that
That's
leads us back
effectively
to
true,
the
but
problem
we-
with the
that
jury
leads us back
instruction,
to
which is
the problem with
life
the
without
jury
the
instruction,
possibility
which is
of parole,
life without the
not
possibility
a
of
sentence,
parole is
and
itself
a legal
not a
sentence,
sentence,
and a
under
legal
the sentencing
sentence,
statute,
under the
to
sentencing
apply to a
statute,
juvenile for first degree murder.
to apply to a juvenile. It's
You-
not listed in statute, correct?
Yes,
It's
you're
not
right.
listed
I
in
mean, the
statute,
plain language of
correct?
the
Yes,
sentencing
you're right. I
statute
mean, the plain
doesn't
language of the
say
sentencing statute
life without
doesn't
the
say
possibility of
life
parole. It
without
just
the
says life
possibility of
imprisonment.
parole. It just says
And
life
so
imprisonment.
that jury instruction
And so
led the jury to
that
believe.
jury instruction led the jury to
it
believe.
turned the, it
I
just
mean,
didn't
it
follow
turned
sentencing
the,
statute,
it
because
just
it
didn't follow
instructed
sentencing
the
statute.
jury,
Because it
life without the
instructed the
possibility
jury,
of parole,
life
or
without
life
the possibility of
sentence,
parole,
which
or life
in the jury's
sentence,
mind, a life
which
sentence meant.
in the jury's
I
mind, a
guess,
life sentence
what?
meant a life sentence
I
with the
guess,
possibility
what?
of parole.
A life
That's not
sentence
what
with the
statute
possibility of
provides.
parole.
And
But
the
that's not what
statute,
if you look
provides.
at the
And
two
statute,
subsections
if you
together,
look at the
in
two
particular,
subsections together,
it's pretty
in
clear that a
particular,
life sentence means.
it's
under
pretty
the
clear that
statute,
a
life
life
with the
sentence
possibility
means
of
under the
parole.
statute life with
So-
the possibility of parole.
I would
So-
disagree with that. I would disagree with that
reading of the
statute.
because
Reading of
I
the
think you
statute,
still do have
because
to
I
read the
think
statute
you
with the
still
parole
do have
statute
to
in
read the
tandem.
statute with the
I
parole
know that
statute
you're
in tandem.
hesitant to,
I know that you're
concede
hesitant
that
to
point, and I understand,
concede
but
that point,
this
and
court has held
understand,
time and time
but
again that the
this court has
parole
held
statute
time and
and the
time again that the
sentencing
parole
statute
statute
have
and
to
the
be read in
sentencing
tandem.
statute have to be read in
And I
tandem.
might disagree with that, because,
And I might
again,
disagree with that.
What happens,
Because,
again,
we've sentenced
what
a few
happens,
people in this
we've
state to
sentenced
life without the
a few people
possibility
in
of
this
parole
state to
because
life
of the
without the
parole
possibility
statute.
of parole because of the parole statute.
What happens to the legislature? The legislature
What
has-
happens to the
has-
legislature?
in
The
the
legislature
past
has
reformed the
parole
in the past
procedures,
has
and
reformed
what
the
if the
parole
legislature
procedures
changes
and the
that
parole- what if
statute?
the legislature changes that
And
statute?
removes that language, and all of a sudden
And
removes
removes
that
that
language,
language,
and all of a sudden
found
makes
guilty
people who
of
are
first
guilty
degree
or
murder
found guilty
eligible for
of
parole.
first degree murder eligible for parole.
I'm
Do
not-
we have to go back and resentence everybody?
We
that
have
was
to go
sentenced
back
to
and
life
resentence
without the
everybody that was
possibility of
sentenced to
parole
life
because we
without the
read
possibility
the
of parole
sentencing
because we
statute in
read
tandem
the
with the sentencing
parole statute?
statute in
No, I
tandem with
think
the parole statute?
Johnson,
No, I
this
think
court's decision in Johnson
Johnson
versus
versus State
court's
indicates
decision
that
in
it's
Johnson
the
versus State
statute that's in
indicates
play
that
at
it's
the time
the statute
of
that's in
sentencing.
play at the time
Because even though
of sentencing.
Johnson was
Because
sentenced
even though Johnson
in 2000 he was
sentenced-
The sentencing
in
statute.
2000 he was
Yeah.
The
resentenced.
sentencing
statute
statute
is not a sentencing
The
statute.
parole
The
statute
parole
is not a
statute is a
sentencing
prohibition
statute.
on
The
parole.
parole statute is a
Right.
prohibition on
But
parole.
in Johnson, this
Right.
court also
But
considered
in
the
Johnson,
parole
this court
statute
also
that was in
considered
effect at the parole statute that was in effect at the time
Is
that
that the
Johnson
court-
was resentenced.
Is that the court rewriting a parole statute as a sentencing
Rewriting a
statute
parole
when the
statute
legislature
as a
clearly
sentencing
intended to
statute
govern
when the
parole?
legislature clearly
I don't
intended
think
to
so, Your
govern
Honor.
parole?
I think it's just
I don't think so, Your
interpreting
Honor.
what
I think
life
it's just
imprisonment
interpreting
within
what
the
life
sentencing
imprisonment
statute
within the
actually
sentencing
means.
statute
In order to
actually
determine
means. Because
what
in
life
order to
imprisonment
determine,
means, again,
what life
you have to
imprisonment
consider
means,
parole
again,
eligibility.
you have to consider
And to do that,
parole
you have to look
eligibility.
at the, and to do that, you have to
Parole
look at the,
statute. So the only way
parole
to
statute.
interpret life
So the only way
imprisonment
to interpret
is
life
to
imprisonment
look at the parole
is
statute to determine whether or not there is parole
determine whether or not there is
under that
parole
statute.
eligibility.
So, Counselor,
under that
how do you
statute.
rectify the fact that one section says life and the other section says life and the other section
Why
says
bother
life without
delineating
parole?
those
Why
two
bother delineating those
sentences
two
in the statute if we're just going to
sentences
pretend
in the
that there's
statute
no
if we're just
distinction
going to
between
pretend
them?
that there's no distinction
I
between
agree,
them?
Your Honor, that it's
I agree,
interesting that
Your Honor, that
the
it's
capital
interesting
murder
that
provision
the
in the
capital
first degree
murder
murder
provision
in the first
are
degree murder
stated
provision
differently in the
are
statute.
stated differently
You think maybe
in
that's
the
because the
statute.
legislature
You think maybe
intended
that's
them
because
to
the
be
legislature
handled
intended them to
differently
be
in reality in the
differently
world, in
in
life,
reality
in
in the
court?
world, in life, in
Possibly,
court?
Your Honor, but there is
Possibly,
a distinct
Your Honor,
difference
but there is
between
a
capital
distinct
murder
difference
and
between
first degree
capital murder
We
and first
tend to
degree
look
murder.
at capital murder is more
severe.
at capital
but
murder
first degree
is more
murder
severe,
requires deliberate
but first degree
design,
murder requires
intent,
deliberate
premeditation.
design.
Capital
Intent,
murder doesn't require
premeditation.
that.
Capital
We
murder
can be
doesn't
convicted of
require
capital
that.
murder.
It could
We
be
can be convicted of capital
That's
murder
right.
without
So
actually-
that-
why do
that's
we
right.
make that
So
distinction?
that-
Why somebody who does something that's not even as bad as murder, that's not even as bad as murder, gets life without parole, and it's delineated in the statute, it's delineated in the statute. But now you're standing here saying, oh, well, now you're standing here saying, oh, well, section right above it just says life. Section right above it just says life and doesn't add without parole.
No, Your Honor, I'm not trying to say ignore that.
No,
I'm
Your
trying
Honor,
to
I'm not trying to say
ignore that. I'm trying to point out the difference between
the capital
the two
murder
provisions
portion
and
of
the
the
capital
sentencing
murder
statute
portion
also
of the
provides
sentencing
for the
statute
option
also
of life
provides
with the
for the
possibility
option
of parole,
of life with
where
the possibility
the
of parole.
first degree
where
murder
the
sentencing provision
first degree
doesn't
murder
provide
sentencing
for the life with
provision
the
doesn't
possibility of
provide
parole.
for the life with
So I
the
think there is
possibility
an
of
intentional
parole.
difference
So I
there
think there
in
is an intentional difference
creating an
there in
avenue for parole
creating an
eligibility
avenue
within the
for
sentencing
parole
statute
eligibility within
for
the
capital
sentencing
murder.
statute.
But you're treating
For
them the
capital
same.
murder.
But you're treating them the same. That's my point.
Yes, but Your Honors, I think that if this
yes,
court
but
looks
Your
to
Honors, I
Johnson
think that if
versus
this
State,
court
it's
looks
very
to Johnson
instructive
versus
on how
State, it's very
this court should
instructive
deal
on
with
how
this issue
this
here
court should
today,
deal with this
because
issue
there
here
again,
today,
the court dealt with
because
this
there
exact
again,
sentencing
the court dealt
statute
with this
and
exact
the parole
sentencing
statute.
It read them in
and the parole
tandem,
statute.
and this
It
court
read them in
said
tandem,
that
and this
under
court
the
said
sentencing statute,
that
the
under the
language,
sentencing
life
statute,
imprisonment,
the language
under
life
subsection
imprisonment,
2B, which
under
is the
subsection
subsection we're
2B,
which is
operating
the
under,
subsection we're
life
operating
imprisonment
under,
means without parole.
life imprisonment
When you
means
give
without parole,
the
when you
parole statute
give
consideration.
the
And that's
parole
what this
statute
court said,
consideration.
that you have
And
to
that's what this
consider
court
the parole
said, that
statute.
you have to consider
And
the
that
parole
once you consider
statute.
the parole statute,
And that once
life
you consider the
imprisonment
parole statute,
in subsection
life
2B
imprisonment
is without
in
parole.
subsection 2B
And
is
that's
without
how,
parole.
in this case, we
And
know
that's
that
how
Carly Gregg's
life
life
imprisonment
sentence
Carly
is
Gregg's
without
life
parole,
imprisonment
and
sentence
it's not
is
with the
without
possibility
parole.
of parole.
And it's not with the possibility
And
of parole.
kind of going
And
hand in hand with that,
kind of going hand in
Carly
hand
Gregg's
with that,
jury had
Carly
the
Gregg's
discretion
jury
to impose
had
a life
the discretion
imprisonment
to
sentence,
impose a
or
life
if it couldn't
imprisonment
reach
sentence,
that, then let the
or
judge
if it
decide
couldn't
the
reach that, then let the
penalty.
judge decide the
And that's consistent
penalty.
with the
And
United
that's
States Supreme
consistent
Court's
with
holding
the
in
United
Miller,
States Supreme
which
Court's
required an
holding in Miller,
individualized
which
sentencing
required an
hearing,
individualized
after which
sentencing
the jury
hearing,
or the
after
sentencer,
which the jury
considers
or
the Miller
sentencer,
factors
considers the Miller
imposing a life
factors
imprisonment
before
sen-
imposing
life
a life
imprisonment
imprisonment
sentence.
sen- life imprisonment sentence.
And
Neither the Supreme
and
Court nor this court
neither
have
the
ever
Supreme Court nor
laid
this
out
court
step by
have
step
ever laid
laid
out
out how
step by
a Miller
step
hearing is
exactly
supposed to be
how a
conducted.
Miller hearing is supposed
If
to
you
be
look to
conducted.
Montgomery versus Louisiana,
If you look to Montgomery
for
versus
example, or
Louisiana
Chandler versus State
for
in this
example,
court,
or
or
Chandler versus
Gilberry
State in this court, or
the
Gilberry,
Supreme Court and this court
both
the
say
Supreme
that the
Court and this
defendant
court
has to have an
both say that the
opportunity
defendant has to have an
present
opportunity
evidence,
to
to
support
present
the Miller
evidence,
factors,
to support
and
the
that the
Miller
jury or
factors,
the senator,
and that the
it could be
jury
trial
or the
court in
senator,
certain
because it could be the trial
circumstances,
court in certain
consider the
circumstances,
youth and its
consider
attendant
the
characteristics,
youth and
using
its
the
attendant
Miller
characteristics,
factors,
using
and
the
that's
Miller
what happened
factors.
here.
And that's what happened
Greg
here.
had the opportunity.
Greg
to
had the
present
opportunity
evidence
to
on
present
the Miller
evidence
factors
on
and
the
her
Miller
trial,
factors.
her defense trial
And
strategy,
her defense trial
to
strategy
focus
was
on allowing
to
the judge
focus
to
on allowing the
instead of
judge
jury
to sentence
because
her
the
instead of the
sentencing
jury
authority
because
of the judge
the
was only
sentencing
20 to
authority
40
of the
years.
judge was only 20 to
So,
40 years.
I think her trial strategy
So,
was clear.
I think
to
her trial
hope
strategy
that the
was
judge would
clear
sentence her,
to
not the
hope
jury,
that the
so
judge
she
would
could
sentence
get
her, not the
a
jury,
lesser
so that
sentence.
she could get a
Um,
lesser sentence.
But the jury instruction,
SS1.
But the jury instruction,
which is
SS1,
the,
which is
clerk's papers,
the
1093 to
clerk's papers,
1094.
1093 to
It
1094.
lays out the Miller standard clearly.
It lays out the
and
Miller
it
standard
says-
clearly.
It instructs the jury what
and
the
it
Miller
says-
factors
It instructs the jury
jury what the Miller factors are, and it instructs the jury to consider those factors
whether or not
in
it should
determining
sentence
whether or
Greg
not
to
it
life
should sentence
with-
Greg to
well,
life
life
imprisonment.
life imprisonment.
And that, in effect,
And
was
that,
the Miller hearing,
in effect,
just because
was
Greg
the Miller
now
hearing,
says that
just
she
because
wished she
Greg
presented
now
more
says
evidence,
that
doesn't
she
mean
wished
she
she
presented
didn't
more
receive
evidence, doesn't mean
everything
she
that
didn't
she was
receive
entitled to under
everything
Miller,
that she
which
was
was a
entitled
separate
to under Miller,
individualized
which was a
sentencing
separate
hearing.
individualized
And
sentencing
the jury
hearing.
considered the Miller
And
factors.
the jury
and
considered the
exercised
Miller
its
factors
discretion
and
to
exercised
impose
its
life
discretion
imprisonment
to
instead of
impose
letting
life
the judge
imprisonment
decide
instead
her
of
punishment.
letting the judge decide her punishment.
And I think, circling back a little bit,
I think
circling
on the
back
jury
a little
instruction
bit,
issue,
I think
on
it's
the
also
jury instruction
crucial
issue, it's
to
also
recognize
crucial
that
to recognize
Greg not only
that
didn't object,
Greg not
to
only
the
didn't
state's
object
proposed jury
to the
instruction,
state's
which is
proposed jury
SS1,
instruction,
but
which
she
is
actually
SS1,
withdrew her own
but she
proposed
actually withdrew her
instructions
own
and,
proposed
acquiesced
instructions
to the state's
and,
instruction.
acquiesced to the
So
state's
I think that goes
instruction.
beyond waiver.
So I think that
and the
goes
fact
beyond
that
waiver.
Greg agreed to those
and the
sentencing
fact that Greg
instructions,
agreed to those
and
sentencing
now she can't
instructions,
come back on appeal
and now
claim
she
that the
can't
trial
come back
court
on
erred
appeal
in
and
giving
claim
those
that the trial court erred in
because
giving those
she
instructions
agreed to them.
because she agreed to them.
As I mentioned,
Greg
received
received
everything she was entitled to
Greg
under Miller.
received
That
everything she was
individualized
entitled to
sentencing
under Miller.
hearing.
That
The jury
individualized
considered the
sentencing
Miller
hearing.
factors.
The jury
and
considered the
state
Miller factors
and
presented
the state
sufficient evidence on each of the
presented
Miller
sufficient
factors
evidence on
to
each of
support
the
the
Miller
jury's
factors
verdict.
to support the jury's verdict.
It
Submitted evidence on her
submitted
chronological
evidence
age
on her
and how
chronological
her
age,
maturity
and
level,
how her
education level,
maturity
ability
level,
to maintain
education level,
relationships,
ability to maintain
overcame her
relationships,
young age, which was
overcame
14.
her young age, which was 14.
Her family and home environment. Her
she-
family and home environment. She had a tough upbringing
she
in
had
the
a
beginning, but
tough
once
upbringing in
she
the beginning, but
moved
once
out
she
from her
moved out
biological dad's
from,
house.
her
For all intents and
biological
purposes,
dad's house.
She had a
For all
great
intents
home
and
life.
purposes,
Her parents
she had a great
supported her
home life.
hobbies.
Her
They
parents
took her
supported her
to
hobbies.
guitar lessons,
They took her
karate,
to guitar
they,
lessons,
supported
karate.
her
They,
academic,
supported her
academic,
success and
most
success
notably when
and
she
expressed
any
expressed any
issue with her mental health, they immediately took
issue
her
with her
to
mental health. They immediately
psychiatric
took her
to get
to
psychiatric
psychiatric
to get
help.
psychiatric and therapeutic
And then the
help.
other Miller factors,
and then
the
the circumstances
circumstances
of the
of the
homicide offense.
the circumstances of the
Obviously,
homicide
the jury
offense.
here heard
Obviously, the jury
significant
here
evidence
heard
about the horrific
significant
nature
evidence about
of the
the
murder,
horrific nature
of the
It
murder.
heard and saw photos
Um,
where
it
Greg
heard
shot
and
her
saw
mom 3
photos
times,
where Greg
point-blank
shot her
range in
mom
the
3
face.
times,
So
point-blank range in the
obviously,
face. That
so obviously,
the circumstances of the
that,
homicide
the
offense
circumstances
weighed in
of the
favor
homicide
of the life
offense weighed in
imprisonment
favor
sentence.
of the life
So
imprisonment sentence.
this court should
So,
affirm her
this court should
sentences
affirm
because
her sentences
she had a Miller
because
compliant hearing.
She had a Miller
jury
compliant
instructions
hearing,
adequately
the
tracked
jury
the statute,
instructions adequately
and the
tracked
state
the statute,
submitted sufficient
and the
evidence
state
to
submitted
support
sufficient
the
evidence
imposition of
to
the life
support
imprisonment
the
sentence.
imposition
Life
of the life
imprisonment
imprisonment
sentence.
life
And I also want to
imprisonment.
briefly touch on,
And also want to
Greg's
briefly touch
claim
on
regarding
Greg's
the
claim
prosecutorial
regarding
misconduct,
Let me ask you
prosecutorial
about that.
misconduct.
Your comment
Let me
about
ask you
the
about,
the jury instruction,
comment
adequately
about the
tracked
si-
the
statute,
jury
and
instruction
I hate to
adequately
keep
tracked
coming
the
back to
statute,
this.
and I hate to keep, but the
coming back to
statute,
this.
when you say the statute,
sentencing
when you say the
statute
statute,
does not
the sentencing
have an option for
statute
life
does
without
not
the
have an
possibility of
option for
parole.
life without the possibility of
Yes.
parole. Just, it does not have that
Yes,
possibility.
that's right.
It does not have that
So
possibility.
That's right.
When we're in a situation, when we're in a situation because of a case from this court, the Johnson case, the cases where we, the Johnson case, the cases where we every life sentence, effectively every life sentence without the possibility of parole, so we might as well. We're in a situation, we're trying to work. We're in a situation, we're trying to work with that precedent. Can even make the argument plausible. Can even make the argument plausible that a jury instruction that flat does not track the language of the sentencing statute. Tracks the language or tracks the law. Tracks the language. Doesn't that seem like a problem for you where we can't actually track the chose, which by the way, these amendments took place after Johnson. These amendments took place after Johnson. They took place after Miller. That doesn't seem like a problem to you that we had, that doesn't seem like a problem to you that we have to actually not track the statute, to track the
Well,
statute?
I think the sentencing instruction did track the statute. and
sentencing
that it said
instruction
life
did track the
imprisonment
statute,
was
and that it
option,
said
not
life
life without the
imprisonment was the
possibility
option, not
of
life without the
parole.
possibility
of
of
parole.
It didn't actually,
So sentencing instructions didn't actually say life.
sentencing instructions didn't
without the
actually say
possibility
life
of parole. It
with
just
the
said
without the
life
possibility of
imprisonment,
parole. It
and
just
that's
said
what the jury
life imprisonment,
sentenced
and that's
Greg
what the
to.
jury.
And we know
sentenced
that's
Greg
without
to.
parole because
And we know that's
again,
without
going back to the
parole
parole
because,
statute,
again,
going
which
back to
says
the
that
parole
first-degree
statute,
murder is
which
not a
says that
parole-eligible
first-degree murder is
conviction.
not a parole eligible
So
conviction.
technically, Your Honor, the
So
instruction did
technically, Your Honor,
track
the instruction did
track the statute,
especially when you consider
especially when
parole
you consider
portion of
the parole
statute.
portion of the statute.
If Your Honors don't have any more questions about the
If Your Honors don't have any more
penalty
questions
phase
about
of Greg's
the,
trial, I'll move on
penalty
to the
phase
couple
of Greg's
issues
trial, I'll
that
move on to
opposing
the
couple
couple
issues
issues
regarding
that
the guilt
opposing
phase.
counsel raised regarding the guilt phase. First, in regard to Greg's argument that the trial court prospectively denied all motions for continuance. I think that's a stretch to say that the trial court expressly denied any motion for continuance. This was during a status conference. This was during a status conference where the parties were discussing how the case was scheduled in terms of how the case was scheduled in terms of proceeding forward, and general dislike for continuing cases. But it's critical in this case that Greg never moved for continuance. She never sought more time. She never indicated that she needed more time. She never indicated that she needed more time to do anything. There was nothing really right for this court to consider because there was no denial of any motion. So we would just argue that she waived that claim, and that there's no decision for this court, and that there's no decision for this court even to review prospective denial of motions for continuance. Turning to the Monotone issue. Really, Greg argues form over substance here. Because the truth of the matter is that from the beginning of pretrial hearings, the scheduling conferences, she repeatedly indicated that she intended to pursue the insanity defense. We cited in our brief, thorough account of all of the instances where she expressed her intent to pursue an insanity defense to the trial court, and we would also refute contention that the state had the first chance to have her evaluated. It was the court who appointed Dr. Gugliano originally to evaluate Greg for both confidence to stand trial and Monotone insanity. And Your Honor recognized earlier, Dr. Gugliano did not feel comfortable proceeding evaluation based on the fact that Greg was on the fact that Greg was on some, and that there was some medication history in regards to what she was prescribed. So after that, Greg hired her own expert, which was Dr. Webb. She ended up not using Dr. Webb. Hired Dr. Clark, who had the first opportunity to evaluate her, and he just wasn't finished with his evaluation. The state's expert, Dr. Pickett, began his evaluation. Importantly for this point, again, is the fact that Greg didn't object to any of this. There was never a point in time where the trial court said he was going to appoint experts to conduct Monotone evaluations. Greg said, no, we object to that. We don't want her evaluated. We're not going to plead insanity. Her only request at any time was that her expert evaluate her before. But even when the state filed its formal written motion under Monotone, Greg did not object. And Greg did not object. The trial court, it asked, do you have any objection? And they said, no, Your Honor. And they said, no, Your Honor. That any argument she makes that she should not have been evaluated under Monotone before filing her 17.4 is really mooted by the fact that she herself being evaluated even before filing that 17.4B notice. Your Honors, if you don't have any further questions, on any of the issues, then the state would rest on its brief and urge this court to affirm Greg's convictions and sentences.
Any questions for Ms. Hartman?